What you're about to provide is true and accurate.
Yes.
Thank you. Mr. Jorde?
Will you please state your name?
Mary Powell.
And Ms. Powell, do you own or have interest in land that's presently targeted by the Summit proposed carbon pipeline?
Yes.
And which county is that in?
Shelby County, Iowa.
And ma'am, is the land also owned by, or a portion interest owned by the Bonita Schultz Revocable Trust?
Yes.
And what's your relation to Bonita?
Bonita is my mother.
All right. And I understand you also have a brother, and do you have another sibling involved in the properties?
There are actually 4 siblings involved in the property, and my one brother had passed away, so his 5 sons are also involved in the property.
All right, understood. And in your pre-filed testimony, there were quite a few names, so it would be you, your 2 living siblings, and then also your deceased brother's children, all with ownership interests, correct?
Yes, and my mother.
And your mother through her trust?
Correct.
Okay, very good. And you caused to be prepared, along with the other family, what's called pre-filed testimony previously, along with some attachments. Do you remember that process?
Yes.
And insofar as what you have already filed in your pre-filed testimony, were there any errors that you believe need to be addressed?
Yes.
Okay, and what would the first error be?
In page 21 of our pre-filed testimony that we filed on July 20th, to the end of the page, there is a line that starts with sole request. We would like to insert "and at Summit's expense."
Okay, and that was something that should have been in there and was left out, correct?
Correct.
All right, any other item necessary for correction?
I have a typographical error from Micah Rory's testimony. I don't know if you want me to address that here or later.
Let's kind of table that for now, and so just focused on your pre-filed testimony, because I'm going to offer that in a moment. Were there any updates that you believe are necessary to make with that?
Yes, I have updates to our pre-filed testimony.
Okay, and so we don't kind of replow the same ground as we did earlier today. Update, I want to be specific, meaning new information or information that you couldn't have put into your objections, your concerns, your pre-filed testimony in July. Are we on the same page?
Correct. This is all information that came to our attention after the filing of our pre-filed testimony on July 20th, 2023.
Okay, and is, again, just so we'll try to minimize what we went through before, the factual basis, does any of that have to do with things that Summit or its agents or representatives have stated since your pre-filed testimony?
Yes, and including meetings with Summit.
Okay, let's start there. In terms of an update, a meeting with Summit, or where Summit spoke after your pre-filed testimony, anything related to that?
Okay. May I ask for one clarification, just so that I have a full understanding from the board? So I want to clarify what a red parcel means on a KMZ map. A member of the IUB staff had stated that the red is just to highlight the parcel that's being discussed at the time. And if the parcel is not shown in red, it didn't mean that the easement had been signed. However, Eric Skovanek testified on September 7th, quote, "If it is red, then it's an Exhibit H parcel. And if it's not, so we have executed an easement." I want to know which is the correct statement as I testified today.
Well, and I appreciate that. Unfortunately, we can't engage in questioning of the board, but if you have to assume his testimony to be true as he was under oath, so I think you should proceed under the understanding of Mr. Skovanic's testimony.
Thank you.
Okay, so did you there was a meeting you'd want to discuss?
Yes. So this is in relation to our well that supplies the only source of water to our land. We brought information related to our concerns about this back in 2021 at the very first informational meeting that was attended by the IUB board and Jimmy Powell, Summit's representative. At that meeting, the IUB first presented us with information about the possibility of eminent domain, and Summit agents were outside the meeting hall wanting to talk to us about taking our land away from us against our right. I attended a meeting, Okay, to this date, Summit has never spoken to us about any concerns with the close proximity of the well, the pipeline to our well. As of this date, they have never offered us any route changes. Micah Rory testified on September 8th, quote, to open dialogue with the landowner and make every good faith attempt to have a discussion about an easement and about that project or anything else a landowner wants to discuss. Again, no one from Summit has ever discussed our concerns about the close proximity of the pipeline to our well. I attended a meeting in Denison, Iowa on August 3rd. I spoke with Grant Terry, who is the senior project manager for Summit, about the distance the pipeline needed to be away from a water well. His response to me was, there isn't one. And I said, Summit has professed that they are all about safety. What has Summit put in their guidelines for this mapping of the pipeline for the safety about a distance from our water well? He looked me in the eyes and stated, we only need to be 2 inches away from your well. He then proceeded to laugh in my face. He laughed as if my concern was just a laughing matter. Really, how is Summit being transparent, promoting safety, and building trust with landowners when Mr. Terry never did provide any information and his only response was to laugh in my face? Mike Rory with Summit testified on September 8th, quote, we're being professional in the sense that we're doing our jobs and trying to keep dialogue open. Micah goes on to say, quote, we take our integrity very seriously. He further states, quote, my agents are instructed to never opt or shoot from the hip. Our interactions with Summit has not met any of this criteria. On Summit, they submitted a revised Exhibit H for our property on August 21st. I'm not able to tell what Summit revised on this Exhibit H. They never mailed a copy to us. The only way I found out about it is looking through the IUB docket. I'm not able to tell what they changed, nor are any of my family members. If you could please go, and I don't know if I can ask them to pull up an exhibit, is that acceptable?
I maybe can do that in the
Okay.
form of a question.
Okay, I'm not able to determine if their measurements are accurate. When we look at this exhibit, you will see that Summit has lines that are short that actually say they're 700 feet longer than lines that are long. They don't show any, I can't tell from the map if our pipe is 137 feet from the well, or our well is that far from the pipe, or if that's from the fence line. So I would like to at some point have that pulled up so that we could do those accurate measurements.
Yes, might I stop you there? And again, in terms of the category of updates, you're telling us that Summit has sent a new route, or what you believed is a revised without explanation?
They submitted an updated Exhibit H for our property on August 21st.
Okay, let's stop there. If we could please pull up the KMZ for the Schultz Revocable Trust, please.
And it's not the KMC, it's the Exhibit H.
Well,
They're done.
But that's fine. Are you suggesting that Summit has proposed or sent to you and other materials a route different than the proposed KMZ route we're looking at now?
I cannot tell what Summit allegedly changed on their revised Exhibit H. They did not identify it to us. They did not speak to us in any way, shape, or form. The only option that I would have would be to pull out a previous Exhibit H and do a line-by-line comparison to see what they actually revised. So I have no clue what they revised on their Exhibit H that they submitted August 21st.
And that document that is revised, is that something that you might be able to get uploaded to the docket if necessary?
It is in the additional exhibits that you had entered into evidence for us, Brian. I believe it was Exhibit 641.
Okay, then we'll get to that. So let's just kind of pause on that. We'll get to that. In any other update based on new information from Summit?
Yes.
Okay, go ahead.
Eric Scovanet testified on September 6th and 7th. He provided the following information. He talked about 400 feet was the number selected by Summit as an initial screening and offset distance from structural boundary lines. The distance was used for micro routing of established general perimeters, and to include the location of a route close to structures would require a manual review. He continues to state, so that was the screening number used, and essentially any structure within 400 feet of that route analysis was flagged and looked at individually. And then, manually adjusted the route accordingly, if possible, based on that.
Objection, Your Honor.
State the objection.
This is effectively oral rebuttal testimony, which I don't believe is an update to the written testimony. Normally, you have the applicant, you have the objectors and interveners, and then applicant has a reply, but the schedule doesn't, as is normal, anticipate a rebuttal round for other parties. If you did that, for the applicant to have the last word, we'd just keep going on and on and on forever. This just seems beyond the scope of updates, which I think we've been pretty generous here. Normally in these cases, it's really just corrections, factual changes, typos, errors, that this sort of broad general rebuttal to Summit's testimony just is not appropriate for this point in the procedure.
Mr. Jorde.
Well, I think it is appropriate if now this last answer may not have been directly on point, but I think the concept, which we could maybe tighten up, is appropriate, because if Summit has since made statements contrary to their sworn testimony, and this witness has firsthand knowledge and it affects her property and her potential eminent domain rights, I think she absolutely has the ability to update what she could not have known based on their new statements.
And I think we have tried to not pick this fight every time it would come up, but to Mr. Jorde's point, setting aside the difference he and I have more broadly about updates, I do think that some of these answers are extending even beyond what Mr. Jorde's take on it is.
Okay.
I don't disagree partially with that, and again, this is not a professional witness, so maybe if I can try a little better to keep the train on the tracks here, I'd be happy to do that.
That would be greatly appreciated.
Okay, and you're doing, I know you have a lot you want to say and you're passionate, but I want to be precise so I can kind of turn you over to other folks. In terms of an update, we're looking for like a new fact that then changes something that you said, or that you would have added something had you known that fact, essentially. And so if we can maybe keep it, was there another meeting where Mr. Powell was at, or that something material was stated that you needed to update on?
If I could talk about the other information related to the well. A lot of Summit peoples have testified about the close proximity, looking at structures above ground. Our well is above ground. But we have concerns about the well, the pipeline being close to our well and leaching out. And James Powell had testified that small leaks could go undetected. They could go into the ground and potentially contaminate the aquifer. The Earth and Environmental Studies has shown that contamination of water aquifers by CO2 can actually increase the acid level of the water, making it caustic for human consumption, and convert it to arsenic. Given that our line is so close to this pipeline, and that Mr. Powell had testified that yes, small leaks can go undetected, how are we assured that our water is safe? So from that, I reached out to two of the regional water areas. One is out of Avoca, Iowa, to see if there was a possibility that we could tap into their regional water. I was told that their line, they do not have jurisdiction any closer to our property than 2 miles north of Erling. Our property is 5 miles north of Erling. He said that they've been waiting to testify because Summit is wanting to take primacy over their water lines, but they have not been heard from the Iowa Utility Board about being able to testify on that. He suggested that I reach out, to the Rural Water Company located in Manning, Iowa, because they have jurisdiction to see if we could get rural water to our land. They said that their pipeline stops 6 miles northeast of our property. I said, is it possible to get it there? And he said, it would be very expensive. You don't want to do that. So I asked him to please send me a quote. He did. To get rural water to our land to possibly protect the water that we consume, $303,000. I contacted a well digger to see if we needed to move our well to get it further away from this pipeline. What would the cost of that be? So this was the gentleman from the Department of Natural Resources that I spoke to, and his name is Eric Day. And he stated that we would have to drill down. He said, gave me information of who to contact. One of the aquifers that we would possibly need to reach to get water for our land is the Mississippian aquifer, which is the same aquifer that Summit Carbon Solutions wants to take water from to cool their towers. So not only wanting to rob us from the air that we breathe, the land that we own, but now they want to take away the water that all of us in this room need for human consumption. So a cost that I got for digging a new well is $220 per foot to dig a well, a minimum of 60 to 70 feet if they put the well where the current well is, which has a really good source of water. But that would defeat the purpose of getting it away from there. So if you had to move it up, you could be digging down to get to the Mississippian aquifer is over 350 feet. If they drill and they don't hit water, or they hit an inadequate source of water, we have to pay $60 per foot for that ineffective drill, plus any equipment that they lose in the ground at the time when they are drilling it. We have to pay for a pumping station to be up by the ground to run all new water lines, all electric. So possible best case scenario is $50,000 to $70,000 or more dollars to get a new well dug. My mom is on a fixed income. We have already spent over $11,000 on this project, and that includes loss in wages for us as children to attend the meetings to testify, all the loss in mileage, gas, motel expenses, everything related to all that we are doing, copying expenses. That's $11,000 coming from someone who is on a fixed income for a pipeline that they didn't even want. And to look at that individual and say, okay, now you potentially have to spend $303,000 or $50,000 to $75,000 to protect the water that is consumed, again, for nothing that we had wanted.
Let me step in there. So again, I think this kind of ties back to the well and the failure to move the line away from the well, and then uncertainty with this revised route from August. Is that kind of, we kind of summarize the kind of the concern here?
Correct.
Okay. All right. And I think you've done a nice job on the well relative to the new summit map after your pre-file testimony. Is there a separate area of concern, I mean, that needs updating specifically?
Yes, it's related to safety. At the meeting on August 3rd, I spoke with Kaylee Langren from Summit about their emergency safety plan. I asked, she said that they had it finalized, so I asked if I could see a copy of it. Another Summit representative came up and did a lot of backpedaling and said, oh no, it's not finalized, it's in draft form. So if safety is their priority, how can you not have your safety plan and to be willing to share that? Jimmy Powell had testified about a case ever since the first meeting, refusing to release plume modeling. He had in his testimony had talked that every landowner who would potentially be affected by this, that they have the plume modeling for that land. Why, as we landowners, have not been able to get access to that? He talked about a public awareness program that will be for every landowner, even those who have adjoining land to the property. If public awareness is for that, then why weren't those individuals allowed to testify before the IUB when even Summit verifies that their health and safety is at jeopardy? When I asked one of the gentlemen from Summit at the August 3rd meeting, I said, can you tell me what the kill zone is related to a rupture? He looked at me, and again, I was laughed at in my face. What do you mean kill zone? Information that's been provided at the hearing relates to the potential loss of life for this hazardous pipeline. Yet Summit's representative laughed in my face as a loss of life is no laughing matter to me, but obviously it was to Summit. During James Powell's testimony, he talked about the modeling that they did being 1.3 miles from their high concentration area. He identified only 1.3 miles of concern of the 680 miles of pipeline across Iowa. So only the people that live in those 1.3 miles are of a concern, or those are the only lives that matter?
Objection, Your Honor.
State the objection.
Again, I think we've strayed quite a ways outside of just updates, but also that response both misstates the law and misstates the record. Actually, the chair has addressed this issue before. High consequence is not a determination that Summit calls things. That is a federal regulation. Mr. Powell's testimony was not that we are only concerned about the high consequence areas. To the contrary, we are applying the integrity management rules that are applicable to high consequence areas over the entirety of the pipeline. So it is just misleading in the record to suggest that Summit is making a determination that some persons or areas are high consequence and others are not, and treating them differently based on that assertion. So two objections. One, we really shouldn't have the record muddled with these sort of misstatements of fact and law, but also we just, again, strayed into just sort of general testimony, not anything specific to this part of the process.
Mr. Jorde, do you a reply?
Well, I don't know, such a long statement. As to the last part, again, I'm doing what I can here to try to keep a very passionate and informed witness, specific to certain things. But as terms of Mr. Dublinsky's colloquy as to law and fact, I mean, she's sworn she can testify what she believes her facts are. The board can sort it out. So that's my response.
Okay. Mr. Jorde, if we can confine and get back to corrections as defined in our rules and move along.
So, ma'am, in some of the questions I'm asking you, you're adding maybe a little bit more than is maybe technically necessary for what we're doing here today. And so, in terms of those corrections or the updates, again, based only on new information, do you have any other like topics before we get into all of what you'd like to say?
Yes.
Okay, tell me one topic that.
Our CRP land?
Okay, and then let me ask you a question.
Mm-hmm.
Do you believe that relative to your CRP land, Summit has made some type of a mistake, or that this new proposed route as of August would somehow affect that differently than it would have in July?
Correct.
Okay. If we can just keep it kind of real narrow with those kind of guardrails, what's the update as to the CRP?
At the August 3rd meeting in Denison, I asked them how they plan to access our land because we are right along Road F-16, and our property adjoins to another Exhibit H property, and I asked them how they plan to access that property. They told me that they could drive through our land to get to the other property, that they could use that right of way, run their equipment up and down it. They could store their equipment on our property, on that land, overnight, potentially leaking gas and oil out to our land, and we would not be able to do anything in relation to that. I also reached out related to our CRP land, and I spoke with the office in Harlan, Iowa, Weston Hughes. They stated that they've had no contact from Summit yet on how they would address CRP land. He told me for the CRP land that we have, if there is any disturbance to that, they will come back on the landowner, not on Summit, and that we would be responsible for having to pay back all previous payments. They recommended that worst case scenario, if Summit had to go through our CRP land, which their pipeline does, that they should bore underneath it. The CRP pipeline has very strict rules and regulations on what the slope and the grade of the CRP land needs to be. Summit's easement document that they uploaded again on August 21st states that they can change the slope and the grade of the land to meet their needs. That violates our CRP contract. I asked them if it would be a potential to, if we didn't want to travel over this pipeline for safety reasons, could we put that extra pipeline land in CRP? He said you could, but with Summit having a forever eternal easement, the minute that Summit goes back on and disturbs that, we as a landowner have violated our contract and would have to repay everything that was paid to us up front. So what is our option? I don't know what we have to do related to that. Summit had talked about an Exhibit C and had stated, Mr. Rory, that we didn't get CRP language put into that. So it's concerned about changing the slope of our land.
Okay, and the CRP. All right. In your pre-filed testimony, you have a substantial number of exhibits and attachments and very detailed information. Would you like all of that to be come part of the record here?
Yes.
All right. We would offer exhibits 372 through 390.
Are there objections?
To the extent that those are the pre-filed testimony and pre-filed exhibits, no objection.
Correct.
Okay. Seeing no objection, the board will admit.
And then earlier I said we'd table something, and I want to come back to it before others ask questions. You had talked about the DNR documents and some water line information. You referenced those and stated that those have been since uploaded as a hearing exhibit. Is that correct?
Correct. I believe the water well estimate was uploaded this morning.
Okay. All right. And I would then offer exhibit 641 and 652.
And we have no objection to 652, and we have no objection to most of 641, But as was set forth in a written motion that was filed, we do object to, I believe it's pages 67 through 74 of 641. And I won't repeat all the reasons that are in the written motion unless the board has not had a chance to look at that.
We have objections are noted. We will give the weight due. Thank you.
Thank you. And with that, ma'am, now all of your evidence is in. I notice you have a substantial amount of paperwork.
Sorry, real quick.
Oh, sorry.
I'm sorry, Mr. Whippel, did you want to get a note on that objection? I moved right by it, and I apologize.
Nope, I'm good.
Thank you. Appreciate it. Sorry, Mr. Jorde, go ahead.
That's fine. Thank you. I notice you have a lot of documentation in front of you and some papers in front of you. And I'm not trying to short circuit this, but I'm trying to stay with kind of the protocols. Was there any other information that you believe would be necessary? We could upload it. I could upload it while you're testifying, for instance, that you think's important that you haven't gotten to.
There's other information related to the pipeline route, the 126 miles, and that of no ethanol plants from Shenandoah, Iowa to Galvin impacting landowners in Montgomery, Pottawatomie, Shelby, and Crawford County, and that was again a conversation on August 3rd with Summit. Information that Summit submitted to landowners, which is part of one of the exhibits that was uploaded recently, an August 3rd handout that they gave to landowners. Alleged contacts by Summit and a lack of contact. I had actually asked Summit on August 3rd, their representative Sabrina, for an updated offer on our easement. She said, yes, I'll have a landowner get right back to you. Mr. Powell testified in his testimony that they would get back to landowners within 2 to 3 days. It has been 3 months and there has been no contact from Summit. We did tell them that we wanted them to go through our attorney, but when I checked with Brian, they have had no contact from Summit wanting to talk to us about any of our land or anything. And I had personally given my address, my phone number, and no contacts. Again, the close proximity to towns in that Erling, Iowa was listed as Mr. Powell testified that he knew nothing about Erling, Iowa's concern of the close proximity to the pipeline. I am the one who, in person at the meeting on October of 2021, told Mr. Powell and the IUB board about the close proximity to many small towns and asked if their intent was to wipe Erling and Westphalia off the face of the map. So the fact that Summit chose not to take any action for 2 years because Mr. Powell had stated, in this late in the game, I'm not willing to amend my application before the board, which would require moving the pipe. And then the lack is what they had talked about for emergency training. Mr. Powell had testified that they would do desktop training. I, as a healthcare professional, have involved in desktop drills. They are nothing like the real world. Lack of transparency from Summit. I did not learn until I listened to Micah Rory's testimony that they have the ability to go back into our land and put in a 24-inch pipe at any point in time for all eternity till the end of the Earth's existence. That was not mentioned anywhere in the property. I thought, or in any of the easements, I thought when they were talking 24, it meant at the time of initial construction, not for the end of the Earth's existence. And the fact that plume modeling was not done based on a 24-inch pipe and the amount that that can cause to loss of life is something else to address. And then concerns about the easement itself and about their Exhibit H document that they uploaded again. When it talks about they can make permanent changes to our land, so does that mean they can put a paved road now through that easement? It talks about that they're going to return it to satisfactory conditions. Who's satisfactory? They state that they will return our land to, quote, pre-construction levels. How do you take no-till soil, dig it up, put it back on the ground, and now say it's pre-construction level? It just doesn't seem possible. The IUB had said that we just submitted 3 objections. We have done multiples on that.
Okay. And I appreciate you kind of summarizing all of those. Thank you very much. And now I will be turning you over to others for cross-examination. Thank you. Or unless we're breaking, I shouldn't have spoken for the board.
No, you're all right. I appreciate it. We are right at noon, and this seems like a good spot to stop. So I have, as soon as we get back, Mr. Taylor and then Mr. Whippel, and we will get back to cross-examination of the pre-filed at shortly after 1 o'clock.